Number 62, the people of the state of New York versus Reginald Goldman. We'll give counsel an opportunity to leave the front tables, and then we'll begin with number 62. Counsel?
May it please the court, Robert McIver on behalf of Appellant, the Bronx District Attorney's Office. May I reserve 2 minutes for rebuttal?
You may, sir, and please try to keep your voice up.
Yes, Your Honor. The notice discussion in A Bay related to the unique circumstances of that case and does not create a right to an adversarial search warrant application for an incarcerated defendant. The proof of this is in Abe A, both in terms that it concerned the right to be left alone and then placed the discussion of notice only in the initial intrusion.
But where does Abe A, or for that matter, you can point me to any case, does it suggest that the right to be left alone would not encompass the seizure of bodily material, a bodily intrusion? Anywhere would I find that?
Particularly in the form of cases that we cite, such as Seacrest, that indicate that the first level of the analysis is removed when an individual is already in lawful custody. Now, even assuming that the
Yes, you want to be left alone so that you're not stopped or seized. I'm not disagreeing with you that, of course, that encompasses the right to be left alone, but I'm not really clear why the right to be left alone doesn't include a bodily intrusion.
I think that the response to that is that the second step here, whether the notice applies throughout, is still satisfied by the issuance of the ex parte search warrant application. That would be consistent with CPL Article 690.
Well, I don't think that's what Abe A says, right? What Abe A says is you have these basic essential tenets of due process, which are notice and the opportunity to be heard. And then as it's going through in the first step with respect to the seizure of the individual, that has a particular standard, right? Probable cause that applies. And as it's going through the second step, as in the search and seizure of the individual's bodily materials, that has an additional multifaceted factor test that you have to go through to ensure the propriety of that type of intrusion. I'm not really clear, other than this kind of structural argument you're making, that you're only mentioning opportunity to be heard and notice in this first provision and not the second. You read it that way, that must be what Abe A entailed, but it strikes me that really what Abe A is doing is saying these are the basic tenets, they always apply to a request for a search warrant, but if you want bodily materials, you've also got to satisfy this multi-factor test.
So there's two responses to that. The issue in A Bay, the notice provision, was required by such circumstances of that case, which differ significantly from the case at hand. With respect to the fundamental notion,
isn't Abe A just saying that if there are no exigencies, then of course you have to provide notice and an opportunity to be heard? You're not arguing in this case there were exigencies, are you?
No, we're not.
Okay.
With respect to my response to that is that with respect to fundamental tenets of the Fourth Amendment, there is no more fundamental tenet than the issuance of an ex parte search warrant application. That is the core protection with respect to exigency. Issues of exigency typically apply to situations in which the people are seeking to avoid the issuance of the ex parte search warrant application, such as Missouri v. McNeely, where the issue was, is there sufficient enough exigency where the people could obtain blood draws or buccal swabs without going the typical route. Here we embraced that. And now with respect to the idea that the invasiveness of this procedure would create the right to the adversarial search warrant application, I think the invasiveness in the case at hand is what...
Well, how is government put in a worse position by providing notice and an opportunity to be heard with respect to the type of intrusion itself, and whether or not it violates the Constitution?
Well, by providing notice and an opportunity to be heard, we would be exposing potential witnesses in nascent investigations to an individual who would be able to peek behind the curtain of an adversary of a search warrant.
Why isn't that true when they're at liberty? Why isn't that true when they're at liberty?
Well, I think that the issuance of an ex parte search warrant would also apply to an individual at liberty, and I would direct the court's attention to People v. Cassetti. I think that that's one of the issues with respect to the notice discussion in A-Bay. If it relates to the such circumstance of this case, in 1985, 3 years later, this court cited to matter of A-Bay and specifically said, it is clear that a search warrant may validly be issued to obtain a blood sample in the event of a violation of the penal law. So we can read A-Bay consistent with People v. Cassetti and consistent with nationwide practice, including Kalikowski out of Washington, that directly addressed the issue in this case.
But counsel, can I ask you a question here? If your office had a suspect who's out, not incarcerated, and you wanted to take a DNA swab, what would the procedure be that you would follow?
I think typically, if we had obtained a search warrant in that situation,
Now you're deciding, what do I need to do? So what do you need to do to get that DNA swab?
obtain an ex parte search warrant application and send detectives out to find the individual. Whether they bring him into custody simply by saying, we have a search warrant, here's the search warrant, sir, you can look at it, and then obtain the buccal swab, or if they were to find the individual and then satisfied to bore for that initial intrusion, if the individual had engaged in a vehicle stop, that would
And when
also-
you hand them the search warrant, you just hand them the sheet that's the search warrant, right? Not the supplementing affidavits or
the signed order from the court, correct, Your Honor.
Right.
So does A-Bay have no effect on anything you do?
I think A-Bay has to be consistent with Cassetti. And so A-Bay is limited to the circumstances contemplated in that case. To the extent that it created,
Well, I guess what I'm asking is, do those circumstances ever come up in in real life? Or is A-Bay just something that you never have to pay attention to?
I think in A-Bay, the Manhattan District Attorney's Office went about it a particular way, and we decided to go the ex parte search warrant application. And I don't think that those are mutually exclusive, as long as you're looking at Cassetti and indicating that a search warrant would satisfy all applicable Fourth Amendment.
But don't you have to break down the components of elementary due process in a particular way for you to effectively comply with A-Bay? So we have notice, which was given, opportunity to be heard, which it was, the lawyer spoke here, and then there's the adversarial hearing, and that's really the question here,
Correct.
isn't it?
Yes.
All right, so the adversarial hearing, I think, is more problematic. But I don't see, I see how the people complied with the first two prongs there. And the question for us really, as I see it, is the adversarial hearing. And elementary due process does not require an adversarial hearing. It's not the same as an opportunity to be heard.
That's my understanding as well, Your Honor. And I would also, I don't mean to answer a question with a question. I
Go
understand.
ahead, knock me down.
How does an adversarial search warrant application, how does my opponent's rule work for a suspect who is not represented by counsel? I don't have the answer to that question. I don't know if it would be pro se, if we would be appointing counsel for somebody who's a mere suspect. I think that's a significant expansion upon a relatively casual notice provision, limited to the circumstances of A-Bay by the text of that very case.
Counsel,
but
can I
the
ask- can I ask a
question
Can I
is-
ask a question, please? Piggybacking on Judge Garcia's question, expanding that example. If you had a suspect in a homicide, and you had information, probable cause to believe this guy is the one who did it, and information that he had a bullet that was related somehow to the shooting, and you wanted to get at that evidence, what would your office do in that circumstance?
So this
How
would-
would you proceed to bring him, to collect that evidence?
So this is the bullet that's lodged in the
Yeah,
individual?
in the suspect.
I think the procedure would be generally dictated by cases like State v. Crowder and Martin. They're admittedly not New York cases, but they were cited to in this. And I think that we addressed that in our initial brief, that I think the procedure there is to obtain a court order at which we would demonstrate the three prongs of A-Bay, and then give that to the defendant and allow the defendant to challenge it after the issuance of the order, but prior to the execution. And I think that is what happened in State v.
So the suspect would have an opportunity to be heard with respect to the nature of the intrusion into the body. Is that what A-Bay is all about?
When there is a significant enough possibility of harm, yes, I think that Winston v. Lee and Crowder and Martin allow for that, but it's far removed from buccal swabs in the case at hand. And I would also
And
note-
along those lines, I'd like to ask a slightly different question. So in King, which, by the way, involved a warrantless search
Yes.
for DNA.
I didn't mean to interrupt. Maryland v. King?
I'm sorry, yes,
Yeah.
Maryland v. King, yes. It involved the statute, and this statute provided a variety of conditions and limitations on the use of the DNA once it was collected. We have things like that in our executive law, right? Do those limitations apply here? And were they imposed, were any limitations imposed by the search warrant here?
Your Honor, I have to be honest, I don't know the answer to that question. I know that to the extent that my adversary raises policy concerns with what happens to these samples, they would be, to the extent that they haven't been addressed by the legislature, it would be best left for them without creating adversarial search warrants that would be inconsistent with the application of CPL Article 690.
Thank you, counsel. Counsel?
Excuse me. Good afternoon, Your Honors, and may it please the Court, my name is Alexandra Mitter, and I represent Respondent Reginald Goldman. I'd like to pick up sort of shortly where we left off, which is what happens when the state wants to take a person who's been charged with no crime and who is walking on the street, and they want to take a bullet out of him. And that situation is so outrageous that my adversary has to agree that notice and an opportunity to be heard are required. But nothing in Abe A says that there's any distinction between that scenario and the scenario in which you want to take someone's blood.
Counsel, do you want in this situation, going back to Judge Fahey's question, is what you're asking for here the opportunity to be heard on the basis of the search warrant probable cause determination?
Yes, Your Honor. I believe that Abe A makes it quite clear that all three parts of the stringent standard that it was laying out needed to be addressed with a notice and opportunity to be heard. My adversary sort of has turned notice into a courtesy to avoid a perp walk, but for centuries, notice has always been a means to an end.
Well, you would still be heard on the nature of the intrusion, right?
Sure, and that did not happen here. So if that's where we're going, that did not happen here.
But there seems, again, along the lines of what Judge Fahey was saying, a very big difference between that and giving over an affidavit for a search warrant, for understandable reasons, right? So how would you square that? I mean, wouldn't you really essentially be putting them in a position of, we have to give up sources and other things in order to get a DNA swab?
So I think there's a couple points in response to that. To the extent that the prosecutor in any particular case has concerns about giving up sources or concerns about flight, things that appellant sort of raised as broad concerns generally, they are perfectly entitled to make those exigencies plain at the time and perhaps proceed ex parte under those circumstances. But the idea that there might be exigencies generally certainly doesn't give the prosecutor license to ignore what AB requires.
We're using exigency, I think, in a different way here. Exigent to me is something's going to be destroyed and you rush in it.
Right.
I don't think that has anything to do with this case. But I think it seems an unusual process to give access to a search warrant affidavit, which you don't get in any other situation, and granted this is different, based on a DNA swab.
So this is different, and this is an extraordinary situation, and I think that is the premise of Abe A, which is it set out a clear test. When you want to invade the body, when you want to take evidence from the thing that we hold most dear, notice and an opportunity to be heard are required. This court called it an elementary tenet of due process. And so, I mean, this is fundamentally different than searching a cell phone.
It sounds as if what you're arguing is that the intrusion is not measured just by how difficult is the mechanical process, but what is being obtained by it as well. Is that a component of the intrusion?
I think it's both of those things. I think they can be considered together. What is being taken from our body is not only private as a, part of our body, the thing that we hold most sacred, but DNA contains every piece of information that a human being could possibly want to know about us.
Hasn't the Supreme Court said that taking DNA is less intrusive than taking a blood draw?
Well, so I think what's important to note here that in Abe A, this court was not concerned about the level of intrusiveness and in fact acknowledged that the blood draw at issue in Abe A was, quote, hardly less routine than taking one's temperature. But the point was not the level of intrusiveness. The point was that it was invading the body. And it's
I guess my point is that, you know, Abe, I don't remember exactly what year ago it was decided, but it's a pretty old case, and there's been some Supreme Court jurisdiction on this issue since then, and as far as I know, there's been no argument made that our state standard should be any more onerous than how the Supreme Court analyzes the Fourth Amendment. So aren't we sort of guided by what the Supreme Court has said since Abe A?
Well, so a few points in response to that. I think as a practical matter, Abe A could be read as applying the state's constitution in Abe A itself. It didn't distinguish us between the state and federal constitution. And the vast majority of the quote-unquote developments that my adversary has cited, these NTIDs in other states, those existed at the time that Abe A was decided, and this court cited those procedures and said, we don't have that statute here. We're not going to make a statute for the legislature. Our constitution, our law requires more procedural due process. And so I think...
So are you asking us to create a state due process right here?
I'm not asking this court to create something that doesn't already exist. I think what exists in Abe A has not been changed by subsequent developments in the law, I guess is the easiest way to put it. I don't think appellant has cited to any any Supreme Court cases that have arisen since Abe A was decided that cast any question on the validity of the holding in Abe A, which is...
So is there any point in time when they could proceed ex parte, under your reading of Abe A and the federal constitution, maybe the state constitution, that government can proceed ex parte to get an order for the search, for the seizure of the individual, perhaps, and the search and seizure of bodily material?
I think where there is no exigency, and here I'm speaking to Justice Garcia's sense of exigency, the exigency as to the evidence itself, where there is no exigency, notice and an opportunity to be heard are required unless the people can come forward with some specific, fact-specific circumstance.
So counsel, so you get notice and opportunity to be heard that they want to take a buccal swab, they want to take his DNA by buccal swab. You come to court. What is it that the judge needs you to assist on?
Well, so I think there's a lot of things that are aided by having two parties there with, competing interests. I mean, that's how we get to the truth. And here, for example, Aguilar Spinelli was definitely not...
Does the judge need your assistance on her determination of whether probable cause exists?
I believe it applies as to all three, and I think as to the whole, 2/3 of the standard goes to sort of the second part of the intrusion. But this court didn't sort of break it down as between those two, and the only thing, my adversary points to is the specific placement of the paragraph, which I don't think is a fair reading.
And then does the judge need your assistance on the nature of that intrusion, the taking of the buccal swab from the cheek?
I mean, I think, it's going to vary by circumstance. I think in a situation where it's a buccal swab, perhaps less factual development is going to be required on the intrusiveness of the search. But I think on that second step, the reason that the buccal swab will perhaps lead to, there's a reason to believe that the buccal swab will lead to evidence that is incriminating. I think that's an incredibly important thing that having an adversarial back and forth will go to. I mean, for example, here, DNA being on the passenger seat of a car sounds good on its face, but then you learn that my client had been in that car on half a dozen other occasions in the week and a half before.
What about the concern of revealing a confidential informant?
I don't mean to make light of that concern. I think it's a valid concern, but it has to be made in a particular situation. The people are welcome to make that showing, and here they said there wasn't one. So it's hard to kind of think prospectively about when they will choose.
Can I take it a step back for 1 second? A typical warrant, not a bodily intrusion warrant. Typical warrant, you don't get the supporting papers and the application, right?
Correct.
We're all in agreement on that. There's either witness tampering or flight risk. So for those reasons, you don't get those things. Here you've got somebody who's incarcerated, right? And I understood your argument to be at the trial court level that that the defendant did get notice, did get an opportunity to be heard, but that it wasn't meaningful because he wasn't provided with the papers that were supporting the application. And what that says to me is that he wasn't able to cross-examine on those. Is that correct? Do I have that correct?
That's absolutely correct. He was
All
allowed
right.
to be heard on his opportunity to be heard, and then the court said, I don't know why you're here, please go away. So that's hardly an opportunity to be heard in the due process constitutional sense of the word.
All right. So that being the case, I'm wondering how the right that doesn't exist in any other circumstance would exist in this circumstance, particularly when you are given notice and opportunity to be heard and you are already incarcerated. I'm confused how this is a meaningful right that you want to exercise. I get, if I'm defense counsel, I want to do that because I want discovery. I want to know what's going on here. But when the people are conducting an investigation, and that's what this in essence is, why should you be provided with that?
Well, because ABA says that you should be provided with
No,
that.
it doesn't exactly say that. It outlines the parameters, and then it's for us to decide which circumstances we apply them to.
It's
Go ahead.
In a, if you're not done, Your Honor, please continue.
I'm sorry, if it's all right with the judge, go ahead.
No, in ABA, this court said that where there is no exigency concern as to the evidence itself, which is the case for DNA, you can't change that, that it is an elementary tenet of due process that the suspect be given the notice and opportunity to be heard before the intrusion.
All right, and you had that here, though. Now we're talking about the next level. We're talking about an adversarial hearing that requires turning over evidence. That's going back to the distinction I was trying to draw before. There's a distinction between opportunity to be heard and what you're asking for here. You had an opportunity to be heard.
I disagree that we had an opportunity to be heard here. I guess that's
so
the difference.
it just wasn't, you were heard, but it wasn't meaningful because you didn't have access to certain
All
things.
he was able to argue is that I think I should be allowed to argue this on the merits, and that's not being heard.
Didn't ABA cite to Matter
Fair
Barber from the Second Department, which indeed ordered an adversarial hearing?
It did indeed, and it's worth noting that an adversarial hearing was what happened in ABA. Mr. John L. was given a motion on notice, he showed up in court, and they had an argument about it. And so the idea that something less than that is required, I don't think is supported by the
But it
text of ABA.
seems to me that ABA, now has been subject to varying interpretations. Personally, the way I view it is that it wasn't addressing the situation of a suspect in custody. It was addressing the situation of someone who was at liberty. And that was the situation that it, in the context in which it set forth its rules. So I don't know that we can know what the intention would have been for this circumstance in which the suspect was in custody.
So I think in that situation where the suspect is in custody, at the bare minimum, you need notice and opportunity to be heard as to the second and third prongs of the stringent test that ABA set
Well,
out.
that's your argument, but that isn't necessarily what ABA was saying.
Well, ABA wasn't presented with precisely these circumstances, but I think the core of ABA, the motivating distinction that this court was drawing in ABA is that where searches are being done to the thing that we hold most dear, notice and an opportunity to be heard is required. Otherwise, someone can be taken out of Rikers Island, sent over to Bellevue, had that bullet taken out of them, and if there's, as it turns out, no bullet there, the people's argument is that, well, they can sue the city, they can bring a civil suit, but that's a non-solution.
Why isn't a suppression hearing or the civil remedies good enough?
Well, if something inculpatory isn't found, they've invaded your body for no reason, and there is no suppression hearing. And the idea that a civil suit, getting money from the city after your constitutional rights have been violated, after you've been cut open on a table, without being given the opportunity to be heard, the idea that you could sue the city seems to me sort of a non-solution to a problem of my adversaries making by their sort of contortion of ABA.
Thank you, counsel.
Thank you.
Counsel?
Just briefly, Your Honor, with respect to challenging the nature of the buccal swab, I do want to draw the court's attention to the subsequent motion practice in which counsel noted on Appendix Site 43 at paragraph 6 that he was only challenging the reasonable cause aspect. And then on page 52, only challenged prongs 1 and 2 of Abe A. So in terms of the opportunity to challenge the nature of the procedure, he was only concerned with reasonable cause. He was only concerned with the testimony. With respect to...
Yeah, but that still begs the question about whether or not a suppression hearing is good enough. I mean, I think the point that she was trying to make was that the Constitution is protecting pre-deprivation, not post-deprivation in this way, and that's what A recognized. So whatever arguments counsel may have made after the fact is still not addressing the point of what, if anything, should have been the opportunity for counsel and defendant before the bodily intrusion, which is the point of A. What do you do before? What do you do to justify the issuance of an order to invade someone's body?
I can appreciate that. I think it goes to the idea that specialized procedural protections are certainly not necessary in the case at hand because counsel was not concerned with those specialized procedural protections.
Can I ask about, and I should have asked both of you about this earlier, but the YouTube video.
Yes.
You're saying it was properly authenticated?
Correct.
Tell me how.
It was primarily because of the testimony of Gale, but I would also draw the court's attention to Appendix Site 1051. Defense counsel affirmatively concedes that his client is singing in this.
This case predated Price, didn't it?
That's correct.
The trial did itself. So subsequent to Price now. What would you say now? Do you think it was properly authenticated under Price?
I think that Price doesn't set a standard that applies to the case at hand because in Price, the people were attempting to use dominion and control as a means of authenticating a photo. They were trying to show this is an authentic photograph because it's from defendant's social media. In the case at hand, this was not being used for a way that was dependent upon his control of the website.
Was it being used to prove the truth of what was contained therein?
I'm sorry.
Was it being used to prove the truth of the matters set forth in the video?
No, I think what it was being used for was simply to demonstrate association with the other individuals and then potentially motive based on what he was actually...
but to do that, that would have to mean that the redacted video represents what the camera observed, right? So you'd have to show that it's unaltered. And how did you do that?
Through the reasonable and inferential linkages, both in terms of the nature, the indicia of video, the indicia of authenticity inherent in video, which is incredibly difficult to...
Well, how about there's two things I'd look for here. Either an expert testimony that said it wasn't altered, right? That wasn't here, though, right?
Correct.
Okay. Or a lot of times you'll have, as with a photograph or something else, you'll have a statement by a participant that it was a fair and accurate representation of the event. That's usually what you look for in an evidentiary matter. Was that given here?
No, and what this...
All right, so if you didn't do that, then how do you say that it was properly authenticated?
Through the circumstantial testimony, or through the circumstantial evidence in Gale's testimony that defendant was filming this, and that he was filming it in the day after the shooting, and then 2 weeks later it was uploaded. That, plus defense counsel's concession that his client is in the video.
But Gale wasn't there, so Gale doesn't know for sure, right, that this is the video. Gale thinks it is, but doesn't know. There might have been 5 videos made.
And I think that...
Or no videos made.
For the purposes of the threshold determination, I think that this does get us to that point because of the reasonable inferential linkages.
Yeah, but you don't want to put junk to the jury, right? There is a gatekeeper function that the judge serves. And it's very clear from Price and the cases before Price what that minimum standard is. And part of it is to show that it's unaltered.
Well, I think that the nature of, I think we get to that point primarily just through the timing of the video, the nature of the video, the details of the video, and defense counsel's concession that his client is in the video. And I direct the court's attention to Gray, to Broomfield, to Petway, to State v. Lamb, all of these cases that reject a a requirement that you either call the creator, or search the device, or obtain certificates from the website. This court has never required a rigid,
No,
Let me
that's
take you back
true. You
for
don't have
one-
to meet the traditional, I agree with you, and certainly we've said that in Price. You don't have to necessarily meet those traditional approaches. The question is, did the proffered evidence here satisfy that minimum test that has been set up? And again, it sounds to me like you're saying, well, when you look at it, you know it's unaltered. And I don't think that's good enough. I don't see how you do that.
I think it is.
Let me ask you something. Wouldn't the proper analysis here would be, you got Detective Flood, right? He establishes the web page accuracy. That's correct, right? And then the link between the defendant's nickname and the video, is that enough to show defendant controlled? I don't know if it is, but just posting it isn't the same as controlling it. That can be shown by Flood's testimony. So the real question then, I think you're on marginal grounds here in complying with Price. So the question is, if the DNA evidence gets in, that is then overwhelming, and that deals with the underlying weakness of the YouTube video.
I think in terms of that, the YouTube video was heavily redacted. It was a fleeting reference. Once you have DNA evidence connecting him to the vehicle, that
Right, that's
harmonizes
the argument I just gave you.
That's correct.
All right, I understand that. I understand.
Yeah, but the
All right.
DNA merely says he was in the video, in the car, excuse me, which he was several times before the date of the incident. So I'm still troubled by
Judge
that linkage.
Rivera's right. I got it at 7 times he was in the car before the shooting.
And that came from your own witness.
That's correct. But ultimately, I think that it harmonizes with the rest of the proof, including the eyewitnesses to the shooting that demonstrated that it was an individual wearing the shirt, and then
Yeah,
you have
but
the
nobody
surveillance video.
identified, the only person who identifies him is the driver, who's got some other issues, right? Considering that he named someone else initially in this cooperation agreement that he breaches, and so there are other credibility issues related to him, but there's nothing else. Let me ask you this, and I see the light is off, so it's my last question. Did the defendant preserve, for purposes of this appeal, or can we consider the relevancy of the video?
I think that the relevancy and the arguments with respect to the probative and prejudicial aspect of that haven't been reached by the appellate division yet, so it still has to be remanded for that purpose.
Thank
And
you.
then-
Thank you,
And
Counsel.
similarly, counsel, if we agree with you on the other issue about the notice and opportunity to be heard, do we need to reach the issue of the authentication of the video?
I don't think you would necessarily need to, if you agree with me, I think the court can reach that. I don't know that it has to if it were to find it harmless, but I think ultimately at some point it has to be remanded back to the appellate division for some kind of determination of the issues remaining, which might include harmlessness if the court sees fit.
Thank you, Counsel.